But it is required and that
Good evening, house. Good evening.
Good evening, sir.
Okay, thank you. I just want to know if it's not only me that is not hearing anything.
We can hear you.
Thank you. I just want to confirm if I'm not the only one that is not hearing anything. So since I've heard from you, I'm comfortable now. Thank you very much. It's just testing.
Mr.
Welcome, sir.
Falade,
We are
Mr. Falade,
21 on the call already.
Eh?
We
Mr.
are
Falade, we
21 on
see
the call
PhD
already.
on your name. Are you our lecturer?
I'm not your lecturer. I'm one of us.
But we see PhD in your name. We got worried. That's why we are
Why
responding
are you
to
worried?
you.
Why are you worried, sir?
The PhD, is it part of your name?
Yes, now.
I
To the glory
see.
of God, yes.
Okay, because this is an LLM class.
Uh, I want to have my LLM too.
Okay. Welcome, sir.
Thank you. Thank you.
Mm-mm. Yeah, yeah. It's not good. Somebody's getting
Hello, good evening, everyone.
Good evening, sir.
Good evening, sir.
Good evening, sir.
Yeah,
Good evening, sir.
I understand we already have 57 in class.
About 60 now.
And we are still going to have some supplementary results. Some people who originally applied for full-time, but when they couldn't make it for full-time, were recommended for part-time. I've not yet gotten their admission letter. So it's likely that we have maybe like 10 more. Maybe 10 or 15 more. So we are talking about a very big class for an LLM program, a very, very big class. Anyway, what I just want to do today is to introduce the topics to you and then assign your class captain to coordinate the allocation of topics. You know that our LLM program is driven by seminar presentation. And our own duty as lecturers is to moderate the discussion, correct whatever wrong impression has been given or whatever wrong assumptions have been made. And at the end of the day, largely based on the outcome of our discussion in class, set questions for us at the end of the semester. It is required that everybody should participate in or present a seminar. For smaller classes, you want to allocate a seminar topic to a candidate. When we first started the jurisprudence and we weren't having many students, that was a class I used to enjoy because we could be just 10 or 12 and we break down the topics into 10 or 12 and everybody makes a presentation. But the moment the class started being a large class, we started merging people. The problem with merging students to present seminar is that most of the time, only one or two of the group members will show interest. And others would just benefit without contributing. But sometimes it shows, because when your seminar is the basis of an exam question, the man who has participated in the preparation already has an advantage. Then some of the times, in order to find a way of rewarding those who actively participated in seminar paper, we tell them to represent in a few words in the exam, and you are able to catch those who did not participate, so as to differentiate between them and those who participated in terms of academic results. Well, the most important thing is that your personality is determined by how you treat your responsibility. And our collective personality is determined by how collectively we treat our responsibility. There have been some LLM class that you would know they were outstanding. And it will reflect also in the quality of their seminar presentation as well as their performance in the exam. We have seen others too who were just, they were just in the program, especially in our own course, just to get marks. It's usually very easy to determine who is seriously interested and those who just want, I just want an LLM to be written against my name and just any course I will do that will fetch me mark. You can make up your mind that you want to be deeply involved and you want to contribute significantly to this subject area. So that gradually you can become an expert in the subject area. As we tag along in the learning of the subject, you will see that it's the most neglected subject area of law. And you will understand why it is very important. You will be able to identify basic errors that judges and lawyers make simply because of their lack of familiarity with this subject area. So what is the subject all about? What is it all about? It is the same subject that is called conflict of laws that some people call private international law or international private law. Okay? Now, for those who have not done the subject at undergraduate level, this subject is just basically concerned with private laws, not just private laws between persons, involving disputes between persons who are connected with different countries. So you can just picture the entire gamut of your private laws at LLB, whether commercial, whether family, whether commercial or family, it is private because it doesn't involve the state in its capacity as the state. Okay? Now, when people enter into transactions or relationship in the field of private law, they will naturally have regard to the law of their territory. So, a contract made between two persons situated in Nigeria does not throw up any issue of international law because it will be very easy to determine that it is the territorial law of their state that is, when I say state, I mean their country, that will govern their relationship. But the moment You introduce the dimension of a connection with more than one state. Maybe the two of them are residents or citizens of two different countries. Maybe the contract was entered into in another territory, even if the two of them are resident here. Maybe the contract was entered into between two persons who are of the same nationality, of the same residence, but the dispute is coming up in a different country from where they entered into the contract. In all of this, conflict of law says, or this subject area says, you have introduced a foreign element into what is otherwise a private local dispute. And the determination of the dispute will never be the same as it would be if that element had not been there. So this subject area would then come in to provide a number of procedural guides. If the otherwise private relationship involves two countries, involve persons connected with more than one country, you would have to answer a number of questions. The first would have to be, why litigate here? Why are you litigating the matter here now if everything about this dispute relate to a relationship formed elsewhere? We call that choice of jurisdiction. Is about, for example, if the case is going on in Lagos High Court, the Lagos High Court might have to answer the question whether Lagos is the proper forum for litigating the matter. So we call that choice of jurisdiction. Now, the answer to that question does not end the dispute. Can somebody tell these people who are doing another talk to mute themselves? So if the answer to the question, which is the proper forum, is answered in such a way, is given in such a way that Lagos is the proper forum, you have not solved the problem. If there are more than one countries connected, it is most probable that the laws of the two countries or the two or more countries will be different. You might then have a situation where the final outcome will depend on which country's law you are applying. So there is another question that this subject area seeks to answer, which is choice of law. Because there are two potentially applicable legal systems to resolve the dispute. You have to look at procedural rules that will guide the courts in determining which territorial law will be applied to resolve the dispute. So that is the second question. Then there is a third question, which will usually arise after judgment has been pronounced. The parties have gone through litigation in state Y. Because of the international dimension of the dispute, the judgment of the court of state Y might become a subject of discussion in another country. The judgment debtor, for example, might come to state X to seek the assistance of the judicial or legal apparatus of state X to give effect to that judgment. Then state X will then have our own rules regarding, firstly, whether the judgment that is brought from state Y is one that it should recognize. State Y is not going to dictate to the whole world that our courts have given judgment, you must accept it. If there are 100 countries in the world and state Y court gave a judgment, the remaining 99 countries on their own terms must determine whether they would accept the judgment of state Y to the extent that they will give effect to it. That's what is called recognition. Some of the time, merely recognizing the judgment suffices. If the judgment is a declaratory judgment or a judgment relating to status, merely recognizing it suffices. For example, let's use marriage as an example. If a marriage was dissolved in state Y, but in state X, one of the spouse of the marriage is seeking to remarry, that spouse will have to pray that state X not only recognizes his or her previous marriage to the spouse of the dissolved marriage, but also recognizes the dissolution. Because if he doesn't recognize the dissolution, then the consequence will be that that person is not able to enter into another marriage in state X. Okay? So state X will have to recognize the dissolution in state Y in order to allow one of the spouses of the dissolved marriage to remarry in state X. So recognition is an issue which falls under this subject area. Then sometimes you need more than recognition. You need enforcement. If a judgment was given ordering payment of money, and the judgment debtor does not have asset in the country where the judgment was given, you won't give up. You trail him to wherever he goes and he has assets. And you will seek assistance of the courts of that country to realize the value of the judgment you have obtained against him. So in that wise, the courts or the legal apparatus of the state where he has asset must first recognize the judgment you have obtained. But after recognizing it, they must be willing to enforce it for you. So every country must have our own rules for recognition and enforcement of judgment obtained elsewhere. And that also falls within this subject area. So 3 questions. Choice of jurisdiction, choice of law, recognition and enforcement of foreign judgments. Okay? Now, we call the subject international. Why are we calling it international? From the way I've explained to you, you will see that the subject only comes in when there is a foreign element. That foreign element is what makes it international. The fact that there are potentially 1, 2 or more countries whose legal system you have to consider is what makes it international. However, your typical thought of something being called international would mean that there's a universal norm that every country would apply. If you look at it from that perspective, then the subject is not really international. The reason is that every country comes with their own rules. That's why your basic textbook in this subject area will compare this subject area with public international law. In public international law, you'll be told that there are sources and that those sources are international customary law, treaties, and what have you. Basically, and in theory, in the field of public international law, countries are supposed to behave the same way because we pretend that there are rules of a superior legal order that binds them. Okay? But in private international law, what is really international is the facts. The solution, that is the rules of law that will solve it. There is nothing international about it. That is the reason why different legal systems adopt different connecting factors. For example, a common law legal system will use domicile as its connecting factor to determine applicable law in the subject area of status. But the civil law legal system would apply nationality. So a court in Benin Republic, when faced with questions relating to nullity of a marriage that was done, that involved 2 persons who are nationals and domiciliaries of different countries. The court in Benin Republic, being a civil law jurisdiction, will say, well, very well, if the question is whether the marriage was null and void on the ground of capacity, we will use the connecting factor nationality. So if Seidu, a Ghanaian national, married Clara, okay, the marriage, let's say the marriage took place in Benin Republic. And Clara and Seidu are deemed or are domiciled in Nigeria. A Ghanaian court might apply Nigerian law because our own connecting factor in that subject area is domicile. The court will not say these are Ghanaian national. No. We have seen cases where people who have naturalized in the United Kingdom, both husband and wife, they have issues related to their marriage and questions pertaining to capacity arise. The English court will not say because they have become nationals of England, they will apply English law. The reason is that their own connecting factor tells them they should apply domicile. So, if the people are deemed by their own rule to be domiciled in another country, it is that country's law they will use to determine their capacity, not English law. But if the same case we are to go on in France, the French court will use English law because the French connecting factor is nationality, not domicile. So we use this to illustrate the point that there is nothing international about conflict beyond the facts. Every country comes up with our own rules. What is our own jurisdiction rule? What is our own choice of law rule? What is our own recognition and enforcement of judgment rule? And there is no obligation that these rules will be uniform. When you compare this with public international law, you see the difference. In public international law, you want to look at the behavior of states. Against what? You want to look at the behavior of states against international treaties, international custom, which you are already assuming will bind all countries uniformly. But in private international law, countries come with their own formula. With the result that you are not guaranteed that the courts of two countries would arrive at the same conclusion with regard to the three questions: jurisdiction, choice of law, and recognition and enforcement of foreign judgments. So what is international is the facts. As for the solution are municipal law norms. That's why somebody was saying that maybe the better way to teach this subject area is to teach them as an addendum to every of the civil law subjects you have learned in your LLB. When they taught you law of contract and you read all that writing of Sagi, you never bothered yourself to consider where the contract has foreign elements. Maybe Sagi should introduce a chapter on what happens where the contract involves persons connected with more than one country. The same thing with your family law. As they were teaching you marriage, they had already assumed that you only be concerned with marital relations between persons domiciled in Nigeria or Nigerians. What happens where there's a foreign element? They teach you that one there. You come to commercial transaction, you come to land law, you come to, and you now treat it. as an addendum to each of those subjects. Okay? Instead of having the whole picture. Okay? But what the designers of curriculum have done is not to bore you with those things which could really give you a problem, but make it a subject of its own. And that is why when you come to choice of law, you teach choice of law on a subject by subject basis. Choice of marriage law, choice of contract law, choice of tort law, choice of property law, etc., etc. Take any basic text on the subject area, you will see that you will teach choice of law on a subject by subject basis. That's why someone said, why are we waiting until we gather difficult subjects together and make people learn it? Why don't we fragment it? Say, okay, oh, I have taught you contract, but do you know what happens where this offer and acceptance is made between persons living in different countries? Do you know what happens where the place of performance is another country and the contract is breached there? All these throw up private international law issue, which a conflict of law expert will teach you separately. Okay? So that is introducing you to the subjects. And what is the dimension? What are the dimensions of the subjects? What do we mean by dimension? The word has a given number of states. Each state has a legal system. Each of those legal systems we will call a legal district. So that you are conscious that the moment your civil, your private law transaction is between you and somebody who belongs to another state of the world, we are already in the periphery of conflict of laws. That's one dimension. That is the one that is typically called private international law. But that's not all. That's not all. In a federation, you have levels of governments. You have at least two. You have the central or federal, and you have the government of the constituent states. There are some matters that all you need to know is what the state authorities have enacted. There are others that while you are in the state, what you really need to know is what the federal law says. If the subject matter of your private relation is falling within state legislative competence, you must recognize that states are qualified to look at it differently. So that in the Nigerian Federation, for example, Lagos law may not be the same as Oyo law as it affects the particular transaction. And so, where the transaction involves two persons from different states, what is the difference between where it involves two persons from Nigeria and Ghana? No difference. So we now have another dimension, which we call the interstate dimension of the subject. Then we have a third dimension that we call internal conflict or legal pluralism. This one has nothing to do with territory. Mr. A and B are under the legislative authority of the same legislature. But that legislature recognizes each of their personal system of law. It recognizes, for example, that a person be amenable to the law of his ethnic group, or that the person be amenable to the prescription of his religion. And many a times, relationship will exist between persons subject to different personal system of law. That is another conflict. Because if such a dispute becomes a court matter, the court cannot easily close his eyes and say, I'm going to apply this law. You have to have rules that will guide you as to which personal system of law will govern the relationship. So that is the one we call internal conflict or legal pluralism. So those are the three dimensions in a multi-cultural and multi-religious legal system. So Nigeria happened to be subject of all the three dimensions. Okay? Unitary African states would definitely not have what you call interstate. But if they are peopled by adherents of different religion and different ethnic groups, they would likely, like Nigeria, have the legal pluralism or internal conflict dimension. A unitary state that is peopled by a homogenic people will probably, will most likely not have private international dimension or internal conflict dimension. What it will simply have is private international law dimension. We not have interstate dimension or internal conflict dimension. What it will have is private international law dimension, which will occur when our residents or national transact in the private law plane with residents and nationals of other countries. So different countries with our own different dimension. Okay? But a country like Nigeria has all the three dimensions because we are a federation. So we can have as much interstate dimension as we could have international. And because of our legal system tolerating personal systems of law, that is law derived from people's ethnicity or people's religion, we also have the internal conflict or legal pluralism dimension. Okay? So that is to briefly introduce you to the subject. It's a wide subject area and it could be very technical. Okay? But if you apply yourself to it, you could find yourself becoming someone like me. I never did it at LLB. I only wanted to do jurisprudence at LLM, but after meeting with the jurisprudence lecturer and learning that there's another subject he teaches or that he taught, I said, let me go and try. Oh, this subject, this conflict of laws that some of our people did at LLB, let me see what it is all about. And I became interested because it looked to me like a subject that is trying to solve problems that require serious application of logic and common sense. So let's look at our outline for first semester. Our outline for first semester, I sent it to your class governor, and by now you all should have it. Topic number 1, that I call meaning and nature of conflict of laws, is just all the introduction I've given now. You will identify the various terms by which this subject is called. You would appreciate the different dimension, international, interstate, and internal dimension of the subject. Which questions does the course try to answer? That is jurisdiction, choice of law, and the recognition and enforcement. What are the errors that judges and practitioners don't avoid when confronted with any of the 3 questions? Second topic, we have said that the norms are municipal law norms, not international law norms. So we are not going to be looking at basically at customary international law or treaties. We are going to be looking for the sources of Nigerian private international law. Okay? And discussing them. We have statutes. We have judicial pronouncements. Okay? That are related to this subject area. So that nobody comes and tells you that the subject is abstract. No. Just like every other subject area of law, we are applying positive rules. It is only that most people do not identify what those positive rules are or what their implication is. What I count as topic 3, a comparative perspective of interstate and international dimensions of conflict of laws in a federation. A very interesting topic. What we are trying to look there is, we have said that the norms of private international law are municipal law norms. When you are talking about the interstate dimension, you usually will not expect that the norm of interstate conflict laws will be federal. It will also be state. So each state will be able, should in theory, be able to come with its own rules of jurisdiction, its own rules of choice of law, and its own rules of recognition and enforcement. Okay? But federations differ in their treatment of this issue. If you look at it, a federation like United States of America, you look at the level of autonomy that the states exercise in formulating their rules, you will see that it doesn't have to be that because America would apply a rule in the private international law dimension, California will apply that rule in the interstate dimension when the dispute is between her and New York. What do you have in Nigeria? What is the degree of the autonomy that the states have and that they exercise? In a country where you cannot be talking about a state bar different from another state bar, we all go to the same law school. You cannot be talking about a Lagos state law of tort that is different from that of your state. Everybody receives the common law. To what extent should our court be hammering differences in territory when they encounter civil disputes involving a connection with more than one constituent state of Nigeria? You come across cases where fatal accidents had occurred in one state, but litigation for damages is in another. And you find our court belaboring the issue of whether it is the fatal accident law of the state where the accident occurred, or fatal accident law of the forum, that is the court where the action is taken, that should apply. At the end of the day, they will give no answer because they have no deep-rooted idea of the policy considerations. They don't have a deep-rooted idea of the policy consideration. If the fatal accident law of state Y is not different from that of state X, what benefit is there in belaboring the point of whether it is state Y law or state X law you will apply? Okay? Now compare a state with a high degree of docility when it comes to exhibiting autonomy with a federation like United States of America. You find a wide gap of difference, and you find America not to be our copy. You cannot copy America because our situation is not like theirs. Our laws are still largely uniform, such that whether you are applying the fatal accident law of state X or the fatal accident law of state Y, you will arrive at the same answer. So you ask yourself, is it important to belabor the interstate dimension of the issue? Do you not just assume that, look, Nigerian law on this subject area is the same, and then allow the litigant who says, no, Kaduna law is different from Kano's law, and it is Kaduna law that should apply to this matter because the accident occurred in Kaduna. Let him be the one to ventilate that, instead of throwing the case away and say, you are bringing a case in Kaduna, you are citing Kano law. Or even if the case is in Kaduna, the accident occurred in Kano, why are you using Kaduna law? Those who will present this paper, they should study the dilemma of the Supreme Court in cases like Amanambo and Okafor and Benson and Ashiru, and understand what we are saying, that why did they even allow the fact that the fatal accident occurred elsewhere to bother them? If the legislation, the fatal accident legislation in the two states are saying the same thing, they will say the same thing because they are copied from the same source. If they are not copied directly from the same source as statute, they will be copied from the same source as common law, received English common law. So to what extent do we belabor the interstate dimension of our conflict of laws? Okay? So look at the title of the topic, and then whoever is assigned with that book, come up with something intelligent. Topic 4, basically discussing in more detail internal conflict of laws. What is the meaning of legal pluralism? Okay? What are the issues that have arisen? You will usually find that there are 3 basic issues. The first one is, what is the formula for attaching a person to a personal system? These are things that we gloss over. We don't give deep consideration. It is assumed that if you are born into an ethnic group, the personal system of that ethnic group will apply to you. If you are a member of a religion, until you opt out, the personal system attached to that religion would apply to you. What of if you are a member of an ethnic group and also a member of a religion? And the two are not saying the same thing. This occurs every day, but we have never sat down to look at it critically. You find a situation where, especially in Yoruba land, and in the subject area of succession, somebody dies. Somebody died, he was a Muslim. But he was also a Yoruba man. Yoruba customary law says something about the distribution of his estate, which Islamic law counters. How do you determine the one that will apply? There have been cases in this subject area. Do you think that the decisions of the court were painstakingly logical? My own finding has been that they exhibit a number of double standards. Okay? That's topic 4. Topic 5. Yes, topic 5 is a very technical topic. Conflict of law, process, and technique. We usually break it further into 2 or 3, depending on the size of the class. Okay? Topic 6, exclusion of otherwise applicable foreign law. It's a follow-up on topic 5. Okay? Some technicality. Then, personal connecting factors. I want to give opportunity to those who will join later. Okay? Next week, I'm not sure we are going to have lecture. I want to give the university the opportunity to conclude admission. So the class governor may start distribution. Okay? But I will talk to topic 5. Topic 5, 6, 7, 8. When we have a full class, and thereafter we will adjourn to give ourselves time to write. But topic 1 to 4, I think it should be easy for you to write something on them now. So the first set of people who are interested can take those ones. The meaning is that we will give you a week shorter and we are going to give others because you have known your topic right from today. So upper week, not next week, because next week is convocation week. I'm not going to do any lecture next week. But upper week, when I will talk to the remaining topic, by that time, the 10 or 15 more people that we are expecting would have joined, so that nobody will tell me that we couldn't do well in this topic because we are not there when you are talking to the topics. Okay? But the first 1 to 4 topics that I have spoken to, by now you should have an idea of what you are expected to do. And I used to have a bibliography. I've looked for it before this lecture. It's in soft form. As soon as I get it, I will give it to your class captain so that you have an idea of what to consult to do a good work. But if you don't have any idea, just go to the library, you will see basic texts. There are books. There is a book by Okoli and Opong. And then you have Professor Agbede's own essays and all of that. Okay? But I will try and see whether I can give a list of possible readings so that you can start. So people who will show interest in the first 4 topics, they look like the easiest topics anyway. First, we will have to make up our mind. How many people are we going to allocate to each topic? Then the topics are not of the same size. For example, topic number 5, we usually break it into minimum of 3, depending on the size of the class. Okay? Even topic number 8 is a very wide topic too. We break it into 2 or 3, depending on the class size. But my intention is to talk to all of them so that those who will do the presentation will be guided. So on that note, let us meet to continue this talking on the topics upper week. You want us to do lecture during convocation?
No, sir.
Okay, but let some people pick up any of the first to 4 topics. Maybe we should
Yes, sir.
assign like 4 or 5. 4 or 5, 4 or 5, yes, maybe 4 or 5. Then, as from topic 5, we begin to break the topics themselves down into 2 or 3, as the case may be, so that everybody will have something to do. So,
Okay, sir.
class governor, you can
Yes,
take
sir.
over. with those who are interested in topics 1 to 4, allocating to them on the basis of the formula of minimum of 4, maximum of 5. Okay?
Okay, sir. Yes, sir.
I'm sure that by upper week, anybody who wants to do our subjects would have joined. And so we'll be able to determine how to allocate the remaining topics, many of which we will have to break down into groups, into further subtopics. Okay?
Yes, sir.
So I see you in 2 weeks' time. So how
Okay, sir.
attended eventually? How many joined?
We have 68 members currently, sir.
The class is we are going to close the class. I'm not thinking of more than, say, 70 something. Because even if we break the topic down to say, let's say we break it down to 12 or 13. If we have 12 or 13 topics, or even 15, okay, we shouldn't be having more than five people on each topic. Otherwise, hangers on will be too many. If you have 5 on the seminar presentation, hardly will more than 2 work. The remaining 3, we just hope to take undue advantage of the working through. But when we see the size of the class, anyway, we will know what to do.
More people will still join, sir.
Especially because admission has not been concluded. Supplementary admission is still being done. So we think that maybe some 5, 6, 7, or 10 more people will join. So anyway, let me go.
Okay, sir.
We appreciate you,
Thank
sir.
you, sir.
Thank you.
Thank you so much, sir.
Thank you so much, sir.
You're welcome.
Thank you, Prof. Have a good night.
Good night.
And congratulations in advance for Nigeria victory over Morocco.
Is it part of the conflict of law?
Yes. 2 countries, international law.
Class rep, how do you intend to go about sharing everyone into groups?
On the WhatsApp group.
Exactly. We should allow the governor to do that.
Okay, yes, that's what I'm asking. So we'll meet in the WhatsApp group so that we can work.
Please, is there a name compilation for this course? Sorry, I want to know because I've not written my name down.
The upload should be dropped soon tonight, where students who are taking the course will fill in their names and their matric number.
Okay.
And
All right. No.
The matric number you have is not. They are still going to have the real matric number, right? And that's the one you are going to be using.
Not all of us that are first year students. Actually, some of us have our matric number.
It's looking to first year students. Once you pay your school fees as first year, you get a matric number.
Now, I'm even saying some of us already have matric number. Not all of us are first year. I just want to know if there is attendance already.
Sorry.
No.
Hello?
Attendance is on the chat. If you just put your number on the chat box, it will be recorded.
I think the governor will do that and collate.
So some of us are, please, we can't, not everybody needs to.
I don't say it again.
Everybody leave.
That's not.
I think it was Prof that set up the Zoom meeting, so it's the one that can actually end it. So everyone should just try to
Governor,
leave the.
communicate with us
Let's
now.
exit one after the other.
All right, good night, everyone.
Good night.
Enjoy the match.
Matthew, please can you hear me? Matthew.
Yes, I can. Yeah, I
So
can.
how do we get? Because I'm paid now. And
Now topic. Classroom. Kindly post the seminar topic on the platform, on the WhatsApp group, please.
Yes, very, very important.
Please kindly send it down. So, okay. So, but I think instead of putting names on the chat box, why not use attendance from the participants and screenshot it? But I put mine, sure. But you'd have screenshot the attendance. I think that's more of a better way.
Cancer
No,
you
the
can assist in
attendance.
that station.
Eh?
The
Can
attendance
assist
will
the
not
governor
carry
in
your
doing
matric
that.
number. Your
You said what?
the participant on Zoom will not carry your matric number, so that's why you have to
The
signify
way
in
you
the
do that,
chat
when
box.
you log in with your name and your matric number. That's what you do. This is academic. That's the standard. Log in with your name, your full name and matric number. First name, second name, and matric number. It's more easier like that. You log in, you tell them that's the WhatsApp guide. You write your name and your matric number beside. Your name, space, matric number. Your first name
That's
and your last name. That's the standard instead of writing this thing like this. So you just
it's
screenshot
okay.
it.
Yeah.
That's the way we do. That's the way it's been done. So that we won't waste time and be writing on chat box. Name, matric number. This is academic now. So
we log in with our names and matric number.
yes, your name, first name and last name. You can put Joshua Chuku, then space matric number. That's all. That's where you log in. If you don't have matric number yet, you can use your name, pending when matric number will come. So it's more easier like that.
But that's for the subsequent class because most people have left already.
Yes, now. Because if you say people should start writing their name on the platform, the whole place will be jam-packed. So just screenshot it like I did yesterday. I screenshot it. Someone screenshot it and send to me. So it's better off like that.
Mr. General, you can see I see the governor to collate. That's my own.
Though I want to see the topic first so that let's know how we can apportion seminar topics.
Okay.
Let's know how we can so that we can start on time and start presenting. So before we start getting busy, please just put the topic. Let's look at the topic because me I also start for jurisprudence. I also start apportioning topics since we have about 7 or 8 topics.
Please do that tonight, please.
Because because if you say on the platform, you say people should start putting their, and some people they will just give them seminar topic and they will leave and they will not do the course.
Yes.
So they just say they are not doing it again. They are still
What about the system of what of the system whereby you have a form, everybody will fill online and send their input?
Yes. I want someone who can do that Google stuff. I don't know. I'm trying to see anyone who can do that Google stuff. Who can handle it? Can you handle it?
There's a lady, the governor of a labor law class yesterday.
Yeah, I saw it. Maybe I will chat her to help me. I'll chat her to help me.
This one, check it.
I'll chat her to help me out with it.
Okay.
Yeah. Thank you very much.
You're welcome.
Yeah. Let me leave the meeting.
I will leave there too.
Yes, sorry. I want to leave. You want to